Hello, Dr. Mohit. Good evening. Welcome.
Okay, Ji, how are you?
Fine, fine, fine. Welcome, welcome. We'll be
Yeah.
starting 7 o'clock. So people are
Okay.
joining.
Okay.
Okay, thank you.
Hello. Yeah, Dr. Mohit, shall we start?
Yes,
Okay.
Kalpesh, we can
Yeah,
start.
yeah, okay. Thank you very much. Good evening to all of you. Today we our esteemed guest, Dr. Mohit Gupta, he'll be talking about how to teach, strategies for teaching maritime law. Again, I hope you'll agree, like maritime law, space law, and couple of more acts have become very the prominent one in last 4 5 years, and then being offered as a elective at various prominent institutions. As per my knowledge, obviously, we'll agree. So, sir, today we'll be talking about part one. I would say I have requested him because Dr. Abhay will be taking because there are so many things are there in the maritime law. So he'll be throwing some light how to teach, what will be strategy for teaching maritime law in the certain aspects. So let me introduce him. Dr. Mohit Gupta is an assistant professor at Gujarat Maritime University, Gandhinagar. He also heads the Center for Research on Maritime Labor Law at GMU. Dr. Gupta has completed his PhD in Maritime Law from Gujarat National Law University, Gandhinagar, and having LLM from Asian University, New Delhi. His bachelor of degree in law is from the RMNU, Lucknow. His area of research include international law, law of the sea, maritime labor law. His publication in reputable journals, including one in ocean development and international law published by Taylor and Francis. In the past, Dr. Gupta has received fellowship from the Korean Maritime Institute, United Nations Office in Legal Affairs, and the NUS Singapore for attending various capacity building program on international law and law of the seas. He sought after speaker and has delivered sessions at prestigious universities in India and abroad, including Bangladesh Army University of Science and Technology, Korea Maritime Institute, University of Erlangga, Indonesia, and NUS Kolkata. So, with this introduction, I, on behalf of the organizing committee, I welcome you and then request you to proceed with the session. Over to you, Dr. Gupta.
Thanks a lot, Kalpesh, for the invitation and for arranging this wonderful course. So I will be sharing my PPT. And let me know if visible. Kalpesh, can you confirm once the PPT is visible? Okay. 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 So the topic which I have been given is strategies for teaching maritime law in Indian law school. So we know that this area, this particular subject, maritime law, as Dr. Kalpesh pointed out, in many law schools in India, it is offered. Uh, in some places, it is offered as optional. In some places, it is offered as a mandatory subject. But yeah, like this area is has a lot of potential. It is very practical in nature. Now, first of all, before starting about various strategies for teaching this subject, I will be first of all discussing about what I am going to cover and what later on Dr. Abhay will be covering. So, for that, I will be first looking at this meaning of this term maritime law. So, when we talk about maritime law, the connotation, this term connotes that law related to commerce and navigational aspect through seas. So we talk about shipping, we talk about maritime labor law, we talk about maritime insurance law, we talk about law of ship errors, and so many branches can be engulfed within this term maritime law. Now, one question which often comes in mind is when we talk about law of the sea and when we talk about maritime law, are both same thing or is there any difference when we talk about law of the sea or maritime law? These two terms. Now, when we talk about these two terms, law of the sea on one hand and maritime law on other, uh, particularly in common law countries, the view of the scholars have been that when we talk about maritime law, the idea is that this particular subject is going to deal with private aspects of shipping industry. So maybe like bill of lading, shipping contract, marine insurance, towage, salvage, all those aspects which are related to private aspects of shipping. Now, when we talk about law of the sea, the idea is that we are going to talk about international aspect of sea, maybe maritime boundary, maybe maritime environment, maybe fisheries. But again, when we go to civil law countries, in civil law countries, the idea is that whenever we use this term maritime law, it includes both the branches, both public aspect as well as private aspect. So civil law countries, like whenever this term maritime law is include both law of the sea as well as the core private aspect of maritime law. Now, when it comes to India, like we offer at Gujarat Maritime University, where I am teaching, we offer LLM in maritime law, and we teach law of the sea, because law of the sea is very important for understanding the core private aspects of shipping, because ships will be using the seas for the voyage, for navigation, and 90% of global cargo is moving from ocean. So ocean law or law of the sea also become very relevant here. Now, why I'm discussing this, because what I will be dealing today, I will be speaking about law of the sea, and later on, Dr. Abhay will be speaking about core private aspect of shipping, which is marine insurance, shipping contract, and all those aspects. So today, I'm going to talk about the rules related to ocean governance or law of the sea. Now, now coming to our topic, when we talk about law of the sea, first of all, what I have seen in past 6 years, I have been teaching this subject, and what I have found is that maps are very important when we teach the subject law of the sea. I know, like when we talk about law of the sea, in many law schools, in international law syllabus itself, there are 1 or 2 modules of law of the sea. But of course, in many other law school nowadays, we have seen that entire subject maritime law is there, where law of the sea has been taught as a module. Now, when it comes to this branch, when it comes to law of the sea, first of all, maps play a key role. Now we know, all of us know, and all of our students also whom we are teaching know that who are the land neighbors of India. They know about all those countries who are sharing land boundary with India. But same thing, they may not be knowing about who are the maritime neighbors of India. For instance, when we talk about Oman, Oman is a maritime neighbor of India. So the point is that whenever we start with law of the sea, I personally believe that the maps play a very important role. Now, from this map which is there in the screen, we can infer many things. We can see who are the maritime neighbors of India. We can also see that there will be some maritime borders between India and some of the countries. Like for instance, India is having maritime border with Oman. India is having maritime boundary with Sri Lanka. So, for instance, when we talk about India and Sri Lanka has a maritime boundary agreement. They have settled their boundary. If there's a maritime boundary agreement in place, in the same way, India is having a maritime boundary agreement with Maldives. So, what I believe is that when we talk about law of the sea, the maps become very important here to understand the various rules which are being mentioned today in law of the sea convention. For instance, when we talk about law of the sea, when we begin teaching law of the sea, we have to first of all talk about baselines, because from baseline all the calculations of maritime zones are done. First 12 nautical mile from baseline is called as territorial sea, and those zones are calculated from baseline. So sometimes those students are confused about how those baselines are made. Now, in that situation, I think again maps become very important. For instance, this map here shows the baseline of India. So every country have to declare baseline, and all those maps are freely available online. Uh, so first of all, those kind of maps become very important. Like particularly, I'm discussing about baseline as of now. So from baseline, first 12 nautical mile territorial sea, then all the zones begins from the baseline. Now, apart from this, there's one more thing which I think is important, is that students can also be told about how those baselines are calculated. Of course, Law of the Sea Convention have the rules. Article 5 of the convention, Article 7 of the convention talks about how baselines are being determined and how maritime zones are calculated. Law of the Sea Convention talks about it. But pictorial display of same concept will definitely make the thing easier. For instance, in this diagram, I want to show like how easy it becomes to determine maritime zones. So if you see this, uh, once a coastal state has made the baseline, has identified the base points, then they have to draw the arcs. For instance, if you want to calculate territorial sea, then 12 nautical mile will be calculated. Maybe like compass will be kept on the base points, and then 12 nautical mile everywhere will be seen, and then the territorial water will be determined. Again, I can quickly show this. If you show this, if you do like this, then the student will get an idea about how those maritime zones are calculated. Now, again, I'm still on the same topic. Suppose, like, I'm talking about relevance of maps in teaching law of the sea. Uh, for instance, this map shows us, suppose cargo has to go, a ship has to go from India to Europe. It has to carry cargo from India to Europe. Now we have in place Suez Canal. So Suez Canal is there. So because of Suez Canal, a ship from India can reach Europe. If Suez Canal would not have been here, then ship would have to take a longer route. It would have gone to the Africa, all over the coast of Africa to reach Europe. Now, from this map, we again get this idea that Suez Canal route is more easier. But suppose I want to explain to my students that there are other routes as well for reaching Europe. Now, in recent time, in past 2 decades, we have seen that there are certain new routes, trading routes, which are coming into existence. One of the route which is coming to existence is in this region. Suppose cargo has to be taken from Japan to Europe. So rather than going through Suez Canal, another option is that a ship can go through Arctic region, because in Arctic region ice is melting in very fast pace, and because of the melting ice, there is no new trade route which has came into existence. Now, so this trade route, which is also called as Northern Sea route, has many economic advantages. Now, earlier, if the cargo was taken from Japan to Europe, now distance will reduce if rather than using going through Suez Canal route, a ship goes through Northern Sea route. So, of course, all this concept, what are the rules related to law of the sea which are applicable in Northern Sea route, Northern Sea passages, and all those aspects, the map play a key role. Now, again, coming to another aspect related to today's discussion, again, when we talk about Law of the Sea Convention of 1982, which is the present treaty, have made specific rules related to some particular aspects. For instance, in Law of the Sea Convention, you will find that there are specific provisions related to archipelagic states. Archipelagic state is a state which is composed of group of islands. Now, why there was a need to have a specific or separate provision related to archipelagic state? Now, the reason why the Law of the Sea Convention had a specific provision related to archipelagic state, this could be understood when we see the maps of those archipelagic states. For instance, when we see Philippine is composed of 7,641 islands. In the same way, when we see Indonesia is composed of 17,000 islands. So that's why those archipelagic states needed a different treatment. So countries like India, yeah, of course, they are not archipelago. So there were rules in place for the countries which were normal, but there were some exceptions, some other countries which were composed of different islands. So for them, there are separate rules related to creation of baseline. So countries like Indonesia, Philippines can make a straight baseline now because their geographical situation need that. In the same way, another aspect related to law of the sea or teaching law of the sea, which I personally believe is there's a lot of relevance of data in this subject. For instance, when we talk about, for example, when we talk about Malacca Strait, under law of the sea convention, there are specific rules related to passage of ship through straits. Now, when we talk about Malacca Strait, or when we talk about why straits were given some different treatment. So in the strait, as of now, Law of the Sea Convention has given more freedom of navigation to ships when they are there in the straits. Now I want to justify why Law of the Sea Convention has given different treatment to straits, or why Law of the Sea Convention has given more freedom of navigation to the ships when they are navigating in a strait. Now, this will be clear when we'll be seeing the data, because straits are very crucial for international trade and commerce. For instance, if you see Malacca Strait, in Malacca Strait, around 94,000 vessels pass every year, and 25% of the world traded goods pass through those straits, which means that those straits, although they are very narrow, so as per data, there are 50 straits which are less than 12 nautical miles. They are narrow, but at the same time, the drafters of Law of the Sea Convention wanted to ensure that the nearby coastal states, which are states which are adjacent to the straits don't exercise excessive control over the navigation of ships. That's why a specific regime was developed under Law of the Sea Convention, keeping in view that straits are very important for international trade and commerce. Again, when we talk about the relevance of data, so like when we see Indian map, Law of the Sea Convention has, so like India has its own exclusive economic zone. Of course, it has, but India also has exclusive economic zone which is being contributed by Lakshadweep and Andaman Nicobar. So Indian situation is like India is situated in a very strategic location. First of all, India has 7,500 kilometers long boundary, which gives a lot of exclusive economic zone to India. And apart from that, the data shows that India is also benefiting because of those islands which are near India. For instance, if you see Lakshadweep, the land area of Lakshadweep is 32 square kilometer, which is very less. But if you see exclusive economic zone which Lakshadweep is contributing to India, it's enormous. Lakshadweep is contributing 20,000 square kilometer territorial sea and 4 lakh square kilometer of exclusive economic zone for India. Lakshadweep alone, although it has land area is really less, but exclusive economic zone which it is contributing in red color, you can see here the exclusive economic zone of Andaman Nicobar, and same is true with Lakshadweep as well. So from this we see that whenever any coastal state has island adjacent to it and that island is itself generating exclusive economic zone, that become very advantageous for the coastal state. uh, Now again, relevant, I'm talking about relevance of data here. Now, under Law of the Sea Convention, today Law of the Sea Convention 1982 has recognized that every state can claim exclusive economic zone, and that can go up till 200 nautical mile from baseline. Now, now when this concept of exclusive economic zone has been recognized today under Law of the Sea Convention, now what are the implication of recognition of this concept? Now again, if you see this map, France, the land area of France is 6,43,000 kilometers square, but exclusive economic zone of France is going in crores, 11 crore kilometer square exclusive economic zone which France is getting today. In the same way, when we talk about USA, land area of USA is less, but exclusive economic zone, which the maritime zone entitlement, the EEZ which it is having is it is huge. That is true with other countries like Australia. Australia, the land area is around 7 crore square kilometer, but again, like we see, exclusive economic zone is much more. So what, from all this data, what we can convey to our student is that this concept of exclusive economic zone has been beneficial. Now the largest beneficiary of this concept have been those developed countries. The data shows this. Although during the negotiation of Law of the Sea Convention, it was developing countries who demanded that there should be exclusive economic zone uh, till 200 nautical mile from baseline. Developed countries during the negotiation of Law of the Sea Convention, they were resisting this concept of exclusive economic zone. But today, the irony is that the biggest beneficiary of this concept of exclusive economic zone have been those developed countries. That is proved from the data which we have in place. Now, again, another thing which I personally feel, which I use while teaching this subject to Law of the Sea, is the relevance of various news items which come here and there. For instance, if I see, if I like, this is taken from PPT which I used in classes. Now, this is a news item which says that US warship was found navigating in exclusive economic zone of India. So US warship sometime back in 2020, US warship was navigating in Indian exclusive economic zone. Now, moment that US warship was was traversing, was found in Indian exclusive economic zone, India issued a statement, a strong statement against United States, saying that the warships don't have freedom of navigation in exclusive economic zone of India. Or India was trying to convey this message that warship don't have freedom of navigation in the exclusive economic zone of any coastal state. So this kind of news items, when they are when student when they are shown to the student get, I personally believe that the student get more the practicality of the subject. Again, when we talk about some recent news item, recently in news, this thing was circulated that Italy was not happy with so many migrants entering its border from the sea. Now, when we talk about Italy passing a law whereby it wanted to curb the migrants who are entering Italy, whether those kind of measures can be justified under law of the sea convention. So this kind of newspaper, all this day-to-day happening, I'm sure they are coming because law of the sea is one area which is very practical in nature, and this kind of news keeps on coming. So I think this also can play a very important role when it comes to teaching this subject. Another aspect is I want to discuss about teaching evolution of this branch uh, of international law, which is we are discussing law of the sea. Now, when we talk about evolution of law of the sea, generally the mainstream narrative, because if you read any book on law of the sea, maybe you read Churchill. Now, the view which is being mentioned here that law of the sea, this branch, or we can the same is true with international law also. For instance, when we teach international law, we say that international law evolved, the modern international law evolved in 14th, 15th century when Holy Roman Empire was disintegrating. In the same way, when we talk about law of the sea, the European author often try to demonstrate that law of the sea, this branch of international law of the sea, evolved around 14th, 15th century when Pope Alexander issued a decree whereby he divided the world into two parts. So this is something which is mentioned in all the books. Like the Pope in 16th century has divided the world into two parts. On one side, Spanish can do trade. On another side, Portuguese can do trade. They can conquer. They can make colonies. So world was divided into two parts, and this was done through a decree which was issued by Pope Alexander. This decree came in 1493. So this is where it is demonstrated that law of the sea. Now, when this happened, when this decree was issued, then there was a scholar whose name was Hugo Grotius, and we also call Hugo Grotius as father of international law. And again, there are a lot of criticism why we call him father of international law. Is it not? Is it true to say that international law rules have came after Hugo Grotius? So this it is sort of a contested statement when we say Hugo Grotius as an important personality in international law. But when we talk about evolution of law of the sea, here again, Hugo Grotius is an important scholar. It is said that when Hugo Grotius wrote this book Mare Liberum, where Hugo Grotius argued for the doctrine of freedom of seas. Hugo Grotius said that oceans or seas are open to all. No countries can control or dominate the ocean. Hugo Grotius says that the countries which have powerful navies, even those countries can't control shipping route, can't control ocean. So this is what is depicted as evolution of modern law of the sea rules. But since we are from South Asia, so we should acknowledge the contribution of our part of the world in the development of law of the sea as well. It may be that some of the books which may be published by Cambridge, Oxford, they have given a narrative. But since we are from South Asia, we have to also convey to our students that ancient civilization of India, of Egypt, of China, we also have role to play in development of international law, development of law of the sea rules. So while teaching evolution, what I personally believe that we should also keep into mind some of the literatures which have been contributed from a scholar from our part of the world. For instance, there's a name, R.P. Anand. R.P. Anand, he's a renowned scholar when you talk about law of the sea rules, law of the sea, and also international law. He was associated with Jawaharlal Nehru, JNU. Now, when we see R.P. Anand also talks about Hugo Grotius. But when R.P. Anand talks about Hugo Grotius, he don't forget to mention that when Hugo Grotius is talking about open seas, or when Hugo Grotius is talking about freedom of navigation, or when Hugo Grotius is talking about seas belong to no one, seas can be utilized by all, then Hugo Grotius was motivated by the state practice which was prevailing in South Asia or Indian Ocean. So R.P. Anand says that it's okay, Hugo Grotius wrote this book, which is Mare Liberum. But in this book itself, Hugo Grotius recognized, Hugo Grotius was motivated, Hugo Grotius looked at the state practice from our part of the world. He said he looked at the tradition of open seas, of freedom of sea, which was prevailing in South Asian countries. So while uh, teaching evolution of modern law of the sea, of course, this book, like John said, this book written by Hugo Grotius is very important. His concept is very important, but we also have to link it with the participation or the role which South Asian countries have played in development of rules related to maritime law. Again, we talk about C.H. Alexandrovich. He again talks about the contribution which our part of the world have played in the development of international law, on the development of law of the sea in particular. Uh, so what I believe is that it may be that a book written by Churchill or any scholar in law of the sea, they might have started from Roman Empire, they might have started from Hugo Grotius, but we being from South Asia, we can talk about our part of the world. For instance, we can mention to our students that seaborne trade was not unknown to us. Seaborne trade was happening in 2300 BC. The trade was happening between Indus Valley civilization and Mesopotamian civilization in ivory, gold, pearl, all those things were traded in 2300 BC. So we are also a traditional maritime nation. It's wrong to say that all of those European countries knew seafaring or they were traditional maritime nation. There are other evidences as well. The place where I am sitting, Gujarat, there's a place called as Lothal. Lothal is considered to be world's oldest port. In the same way, when we see some of the other texts, for instance, when we see Chandragupta Maurya, whose regime was around 322 BC, during his tenure, during his regime, there was a Chinese traveler who came during his regime of Chandragupta Maurya. So he wrote that Mauryan Empire was having a well-established naval department, and it was very active in combating the piracy. In the same way, when we talk about Earth Sastra has entire chapter which is dedicated to seaborne trade. So the point is that this is not new to us. This is not the gift which European has given to us, this international law or law of the sea. We were doing trade through seas. There were rules in place for seaborne trade. I think that kind of narrative should also be told to the students when we are discussing about the evolution of law of the sea. Now, moving further, another aspect which I wanted to point out is teaching the negotiating history of law of the sea convention. So when we talk about Law of the Sea Convention, which is the major treaty, Law of the Sea Convention 1982, we call it UNCLOS as well. So UNCLOS is United Nations Convention on Law of the Sea. Now, when we see this treaty, 1982 Law of the Sea Convention or 1982 United Nations Convention on Law of the Sea, now, first of all, while teaching negotiating history, it should be conveyed to the students that what is the relevance of negotiating history? Why they should know about negotiating history. Now, now this is something which is true for international law as well. Why we should know about negotiating history of a treaty? The benefit of knowing negotiating history lies in, we can see Vienna Convention on Law of the Treaty. Vienna Convention on Law of the Treaty in its Article 32 regards negotiating history as a supplementary tool of treaty interpretation. The negotiating history of a treaty is a supplementary tool of treaty interpretation. Now, in order to further support this point and also to make a student understand the relevance of negotiating history, we can give them an example of South China Sea Arbitration Award, because in South China Sea Arbitration Award, the tribunal was looking at the interpretation of Article 121 of Law of the Sea Convention. But while looking at the interpretation of while interpreting Article 121 of Law of the Sea Convention, tribunal looked at the negotiating history as well. So that's why students should be made aware why they're studying negotiating history, because they may think that they are more concerned about what is the content of a treaty rather than going into what circumstances that treaty was negotiated. Again, when it comes to Law of the Sea Convention, I personally believe that Law of the Sea Convention is one of the best example of teaching a student how to negotiate a treaty, how difficult a treaty negotiation process is. Because when we see this Law of the Sea Convention 1982, the negotiation started in 1973 and it ended in 1982. For 9 long years, countries were negotiating how those rules related to ocean governance should look like. Why I'm saying this, that this treaty demonstrate the one of the best example of how good negotiations happens. Why I'm saying this, the reason is that because if you see Law of the Sea Convention today, if you see the number of countries which have ratified this convention, they are huge. More than 150 countries have accepted this convention today. Why so many countries have accepted this convention today? The reason is during the negotiating history, the draft of the convention was prepared through consensus method. This is one of the technique of preparing the draft of a treaty. So there are two methods how a draft of a treaty is prepared. First method could be that we can prepare a draft by voting. Another method could be we can prepare a draft of a treaty through consensus. Now, what is this consensus method? Suppose we want to insert like a provision in the convention related to island, and suppose some country has some objection. So in the consensus method, the idea will be to accommodate the concerns of all the countries while text is drafted. So law of the sea convention was prepared through consensus method. So like many of the provision in the convention, for instance, Bangladesh wanted that there should be a specific clause in Article 7 of the convention because Bangladesh has unstable coastline. So it was accepted. Many countries wanted that provisions should have separate exceptions. So it was accepted. So during the drafting stage itself, the views of all the countries were taken into account. That is the reason why this treaty is a successful treaty today. So this kind of, I believe that negotiating history is important, and also this treaty, when this issue is discussed in class, at the same time, the students can also be told that this is how the negotiation happens. This is how the this because this treaty is one of the best examples seeing the ratification which this treaty has got, because countries, all the concerns were taken into account in negotiation stage itself. For the moving further, what I want to discuss some further aspects. This Law of the Sea Convention 1982 has created several new institutions. There are three new bodies which have been created through Law of the Sea Convention. First is International Tribunal on Law of the Sea. Second is Commission on Limitation on Continental Shelf. And another is International Seabed Authority. Now, while teaching Law of the Sea, it is very important to open these websites in front of the student and to tell them what resources they can get from each of these websites. For instance, when we talk about ITLOS, now if you see the ITLOS website, if students are showed the website of ITLOS, and because ITLOS website is very rich, if you see this ITLOS website, it has all the data, really, all the case laws which are being, all the jurisprudence which has been developed by International Tribunal Law of the Sea, all those things are freely available. Advisory opinion which have been rendered by the tribunal, or the contentious cases which have gone to tribunal, all are available. In the same way, when we talk about international website of International Seabed Authority, it has a very good database where it is also having a link whereby you can access the domestic legislation of all the countries which are related to deep seabed. In the same way, when you will open the website of Continental Shelf Commission, you will find that all the submissions which countries have made to Continental Shelf Commission with respect to extended continental shelf, they all are available. Whatever recommendations which Continental Shelf has given to the states, all those are freely available in the website. So I believe that all these three institutions which have been created by this treaty, all the students should be conveyed that there is a website and a lot of resources are freely available on those websites. Now, another aspect which I wanted to talk about when I'm discussing about teaching methodology, what I believe is that law of the sea issues should not be looked in isolation. Or this is true for any branch of international law. Suppose you're talking about international criminal law or any other branch of international law, those there's no watertight compartment. None of the branch of international law should be looked in isolation. And this is true with law of the sea issues as well. For instance, law of the issues can be looked from human rights perspective as well. For example, when we talk about human rights treaties, when we talk about torture convention, whether torture convention will apply with, will be relevant, will be important for seafarer who is tortured on a ship. Suppose there is a ship which is moving in high seas and there is a torture which is happening. Whether torture convention will be relevant for the seafarer, whether seafarer or the people who are working on the vessel, they come within the protective ambit of human rights treaty. This can be true with respect to ICCPR. For instance, ICCPR in its Article 2, Clause 1 talks about the scope of applicability of ICCPR. And Article 2, Clause 1 says that state parties have to ensure ICCPR right for all individuals who are within their territory and subject to their jurisdiction. This is the language of Article 2, Clause 1. Now imagine there's a ship, which there's a foreign ship which has come to India. Foreign ship, maybe US flagship, has came to Indian port, and suppose some human rights violation is happening in that human rights in that US ship in Indian port, and we know that India has ratified ICCPR. Whether India is under a responsibility to protect the human rights of seafarers who are there on board foreign vessel in Indian port. So the point is that we should also discuss with our students the scope of application, whether human rights treaty also grant any protection to people who are at distress in sea. So when we talk about people who are at distress in sea, it could be a seafarer, it could be a migrant, it could be a private security guard who is there on a merchant ship. There could be so many people who may need assistance at sea. Whether human rights treaty, whether protective ambit of human rights treaty also extends to those people who are in any distress at sea. So that is also an area which I think should be looked at. Further, when we talk about the same thing, I'm still discussing the human right perspective. Now, for instance, when we read Law of the Sea Convention, under in Article 98 of Law of the Sea Convention, there's an obligation which is imposed on various countries, and this obligation is Article 98 of Law of the Sea Convention talks about duty to help in distress. Now, this particular obligation is mentioned in Article 98 of Law of the Sea Convention, which means that suppose India is the coastal state and there's a ship which needs some help. Suppose there's a ship which is navigating, which is passing, which is there in high seas, and that ship needs some help. Maybe that ship is has collided with an iceberg and it need immediate assistance. Now that ship will give a distress call to nearby coastal state. Suppose it gives that ship in high seas seeks help from India, then Law of the Sea Convention Article 98 imposes this duty on coastal state that they should give assistance to any ship which is at distress at sea. Now, this particular issue, this particular aspect, which is covered in Article 98, which is called as obligation on coastal state to help in distress, to help the ships who are in distress. Now, this obligation under Article 98 is being mentioned in Law of the Sea Convention. But we can tell to our students that there is also a human right aspect to this particular obligation. For instance, suppose India gets a distress call from a ship and India fails to reach timely and give assistance to that vessel. Maybe India or the coastal state reaches that vessel, and by the time the coastal state authorities reaches that vessel, maybe vessel is already wrecked, maybe vessel has already sunk. Now, this issue can be also seen from the human right perspective. Now the question could be, if a coastal state fails to give timely assistance to a ship which is in distress, whether it will result in breach of human rights obligation of coastal state. Now in Europe, there is a lot of jurisprudence on all these topics. So for instance, if you see this last point here, which is a decision of Human Rights Committee. Now, Human Rights Committee looked at this issue. In this case, Malta failed to timely give assistance to a vessel who was at distress. So, Human Rights Committee looked at this issue from human rights perspective. It looked at whether Malta has violated ICCPR by not giving timely assistance to a vessel in the high seas. So, the point is that law of the issues can very well be looked at from human rights perspective. Of course, when you talk about human rights at sea, there are less scholars who have contributed to this area. But of course, they are. For instance, when you talk about scholars like Sofia Galani, we talk about Irini, whose name is mentioned in the last point. Irini, she teaches in University of London, SOAS. Now there are scholars who have, like, in last 10 years, we know that there are scholars who have started to take up those issues, particularly human rights at sea, this particular aspect. Now another aspect which I wanted to discuss related to teaching methodology is the relevance of case laws. Now, this is something which is true with all the subjects, like in LLB, whichever subject it is. The case laws gives a lot of understanding how the arguments are made, what are the various issues which are being involved. So this is true with with the law of the sea as well. For instance, we can ask our student to read Enrica Lexi case, or maybe like South China Sea Arbitration Award. Because South China Sea Arbitration Award, when we talk about South China Sea Arbitration Award, it has contributed a lot in the development of jurisprudence related to Article 121 of Law of the Sea Convention. So maybe when we are teaching our student the definition of island, we can tell to the students that these are the relevant paragraphs from South China Sea Arbitration Award, and they can read them. Another aspect is that when we are talking about law of the sea, we should always keep this in mind, this principle that it is the land which dominates the sea. So country will get the maritime entitlement when they have sovereignty over land. If there will be land, then only there will be territorial sea exclusive economic zone. First of all, country has to demonstrate that they have sovereignty over a territory. Suppose there is a piece of island which is disputed. This is the case in South China Sea Arbitration Award as well. So this principle is very important, that it is the sovereignty over land which gives rise to the entitlement in the adjacent water. Of course, there's another thing which I wanted to point out, that we should always convey to our students that when you talk about law of the sea, it is closely related to IMO treaties or maritime law treaties. So when we talk about international maritime law, there are 4 treaties which are called as pillars of international maritime regulatory governance. There are 4 treaties which are called as 4 pillars of international maritime law. One is Maritime Labour Convention, another is STCW Convention. The second one, which is STCW Convention, it talks about training standards for seafarers who are working on ship. There's another convention which is called as Safety of Life at Sea. That is called, this convention, SOLAS, which is also called as Safety of Life at Sea Convention, talks about various aspects like ship should have a lifeboat, ship should have a fire extinguisher, and so many aspects related to safety. Another aspect, another treaty which is relevant is MARPOL. MARPOL is a convention for prevention of marine pollution. So these 4 treaties are called as 4 pillars of international maritime regulatory governance. Now, we should convey to our students that all these 4 treaties are, are linked to Law of the Sea Convention. They have close connection with Law of the Sea Convention. All those 4 pillars or 4 treaties, which we call as 4 pillars of maritime law, they're closely integrated with Law of the Sea Convention. So for saying this, for telling this to the students, we can ask them to read Article 94 of the convention. Because Article 94 of the convention, Law of the Sea Convention, talks about duties of flag state. Now, every Law of the Sea Convention has in Article 92, Article 93, Law of the Sea Convention has talks about the concept of flag state. Law of the Sea Convention requires that every ship should have a flag. Every ship should have a flag. Every ship should be registered, and the country in which that ship is registered, the flag of that country ship should have. Now, Article 94 says that it is the duty of the flag state to ensure decent working condition on its ship. For instance, if India has given a flag to a ship, then it is the responsibility of India to ensure that the working condition on Indian ship is up to the standard. And where those detailed standards can be found, those standards can be found in Maritime Labour Convention. So Law of the Sea Convention has just said this thing, that it is the duty of the flag state to ensure decent working condition on their registered vessel. Now, a separate treaty, which is Maritime Labour Convention, has been negotiated for telling us what should be the working condition for a ship. Now, in the same way, when you talk about Article 94, Article 94 says that it is the duty of the flag state to ensure that all the seafarers on its flag vessel are adequately trained. Law of the Sea Convention stops by saying this. Now there's a separate treaty which is mentioned in second point. There's a separate treaty which is standard for training, certification, and watchkeeping, which we call as STCW Convention. It gives details of what should be level of training a person should undergo before he joins or works at ship. So I think this aspect is very important. The students should be told that this maritime law, these key treaties, these four treaties which are there in maritime law, they're closely linked with the law of the sea convention. Now, of course, several more aspects I will be covering here. Now, students, while teaching to the students, they should also be made aware about research area or gray areas which are there where they can make research paper. I know like there's submission in every paper. So they can write paper. They can be told, even maybe like teachers can themselves allocate them the topics, the research areas. For instance, when we are teaching them about innocent passage, one of the gray areas is that whether warship can have right to innocent passage in territorial sea of coastal state. In the same way, there are so many research areas, and after the topic, they could be told that these are the areas. This will motivate the students to research further, and it may be that some of the people, some of the students are academically oriented. They want to make their career in academics. Maybe they want to become teacher. They want to do LLM. So that can help all those students as well if we will tell them those research areas. Also, it is important that students should also be made aware about the recent developments which are happening in law of the sea. For instance, in 2023, we have this treaty which is called as ICS Treaty. In the same way, in 2023, there are several countries which have filed case in ICJ related to sea level rise. So all those are recent development, and I believe that students should also be made aware about what is happening in when we can connect all those things with whatever we are teaching in class. For instance, when we are teaching about maritime security, we can also tell to the students that IMO has passed many resolutions related to private maritime security guards which are there on these merchant ships. Also, we should also convey to the students about some of the challenges which are being faced by ocean governance, particularly like issue like sea level rise. When we talk about issue like sea level rise, International Law Commission is working on it. International Law Commission is working on it, which means that this issue is really significant. When we talk about sea level rise, if it is happening, there are certain we should convey to the students that this issue is serious. Because, like, for instance, if sea level rise will happen, then many nations will wipe out. For instance, small island Pacific nations like Tuvalu, Marshall Island, Togo, those nations are small. Maybe they are having the population of 10 lakh, maybe sometime less than that. But those nations are going to wipe out if sea level rise will happen. What about their maritime entitlement? What about the people who are living in those countries who will wipe out? Whether other countries will take those people, whether climate change refugees or refugees, which when those countries wipe out, whether other countries will take them. So all those issues are very important, and students, I think, will be very much interested. And these are very practical issues. For instance, we talk about migrant at sea. In Europe, this is a big problem. Like people are fleeing from Syria, people are fleeing from Libya, and they are there in these small boats. In a small boat, 200 people are sitting, and they want to enter into Italy. Now, whether Italy should take those people, whether Italy should forcefully send them back to Libya if they have came from Libya, because law of the sea convention talks about duty to help in distress. Suppose Italy gets this distress call that there is a migrant, there is a vessel which is full of migrants and it is about to sink. Now Italy is under an obligation to give assistance to that vessel, although it is full of migrants. Now whether what will be the scope of assistance which Italy should give to those people who are there on that ship, whether Italy should give them asylum also, or Italy should send them back to the Italy, Libya or Syria. So all those issues are practical. And for instance, when we talk about illegal fishing industry, like there's a lot of human rights violation when we talk about fishing sector. In the Thai fishing industry, There are reports which talks about slavery. People are trafficked from other countries and they are taken to, maybe like in Thailand. There is a lot of research on this. Lot of research reports are there on this. That many people who are working on the fishing vessels, they have been trafficked. They have been brought from other countries forcefully. They have been brought. So this has these challenges. These are the areas I think those should be conveyed to the students. And further, towards the end, I also wanted to talk about Indian perspective. When we talk about law of the sea, we should also make our students aware about our part of the world. What is the implementation of law of the sea convention in India? What are the legislations which are relevant when it comes to implementation of law of the sea convention in India? Whether Constitution of India talks about law of the sea. So all those things, for instance, when you talk about Constitution of India, yes, it does talks about law of the sea. If you read Article 297 of Constitution of India, it specifically says this thing, that all the resources which are there in exclusive economic zone or territorial sea, all those belong to Union of India. This can be starting point of discussing Indian perspective on law of the sea issue. Now, apart from this, there are legislations which are relevant. For instance, when we talk about the law of the sea convention, one of the most important legislation in India when it comes to implementation of law of the sea convention is 1976 Maritime Zones Act. Now, all those zones like territorial sea, exclusive economic zones, all those zones has been created in India through this Maritime Zones Act of 1976. But we should know that there is very less literature on this aspect. So this is the problem. Like in India, if you see maritime sector in India, it is blooming. But if you see literature, if you see scholarly contribution, it's really less. There's a gap which is present here, and there's a lot of scope to do research, to look to this Maritime Zones Act of 1976, to see the implementation, to see whether how India is implementing, what legal mechanics India has followed to implement Law of the Sea Convention. In the same way, there's another legislation which is relevant, which is 1981 Maritime Zones Fisheries Act. Now, if you read this Maritime Zones Fisheries Act, it lays down the framework. If suppose some foreign vessel want to do fishing in Indian exclusive economic zone, then it has to take a license. And all that design, all that framework has been laid down in Maritime Zones Fisheries Act. But again, there's very less literature on all these topics. I think like students not only should be told about all those issues, and they should also be encouraged to contribute, maybe writing a research paper, like which could be part of their assignment, and which can also be published as a blog or paper, which will result in more scholarly contribution uh, on the legislations which are there in India, which is lacking as of now. Uh, again, just I'm winding up this discussion, but one more aspect here is students should also be encouraged for comparative study. Now there are certain areas, certain websites I can say where a lot of resources are available, and one such website is U.S. Navy website. Very good research. They have spent a lot of money in doing that kind of research. If you go to U.S. Navy JAG website, I think I have opened it. Since this is very important aspect, just want to show you what kind of content is present in this website, which I'm talking about, which is U.S. Navy website, U.S. Navy JAG website. If you see this website, a lot of resources, so much money is spent in all those resources, freely available. Now, if you see this website, in this website, name of all the countries is mentioned in this website. And for instance, you can see here Albania, Algeria, Angola, all these countries, even India is mentioned here. Now, if you download this reports, for instance, if I go to India and download the report related to India. Now, in this report, I will find that what are the legislations in India which are relevant for implementing law of the sea convention. And so if you want to know about domestic laws of any country related to any aspect related to ocean governance, this is the easiest way. You can visit US Navy JAG website. All the countries are mentioned there. Domestic laws of all the countries are mentioned there, and also the comment of US are mentioned, because US continuously keeps on saying that there are certain countries who are violating law of the sea convention. So what is the comment of US related to domestic law of a particular country? For instance, US is of the view that, so there is a provision in the Maritime Zones Act of India that if any warship want to navigate in Indian territorial sea, then it should take prior permission from Indian government. The view of US is that this is the violation of law of the sea convention. So like you will not only know about the domestic laws of all the countries, how they're implementing law of the sea convention by going to this US Navy website, but also you will also see what are the views of US government related to their domestic law of different countries. Uh, Again, like when it comes to comparative study, another resource which is important is ISA website, which is International Seabed Authority's website. Here also you can find the legislations or rules of different countries, how they are implementing the provisions in law of the sea convention related to area. Area is deep seabed. Area is the term which is used for deep seabed or seabed beyond national jurisdiction. This area is used in law of the sea convention. So here again, this is a very important database for a comparative study. So that is what I wanted to cover here, and like if anybody have any specific thing, I will be happy to listen.
Yeah, thank you very much, Dr. Mohit, for really insightful session. You can say like so many insight we have. I am sure like whatever you have discussed in last 50 minutes, uh, 10 or 20% people, maybe they've been knowing about this particular aspect of maritime law. I request participant, you can raise your hand. We will unmute you and then you can ask the question. Yes, participant. Please raise your hands. Mm, Okay, there was question. Which topics from maritime law we can add in UG program of commerce base?
Okay, UG program which of
Commerce in commerce.
okay.
BCom we can say, yeah.
Okay. So when it comes to like 5-year LLB or 3-year LLB, what I personally think that students should be at least given a choice, like as an optional subject. This particular subject can be introduced, and already it has been introduced in many law colleges, because this is very practical in nature. If you see like trade, 90% of trade happens through oceans, and there's also a lot of scope of litigation. So suppose like some after doing LLB, if anybody want to become a maritime lawyer, if he will have understanding of maritime law, that will help a lot. So like there are in Bombay, if you see like Bombay High Court traditionally had this admiralty jurisdiction. So there are many people in many lawyers in Bombay who are totally practicing in maritime. There are many law firms who are totally talking about ship. They are dealing with cases related to ship arrest. And also after 2017, all the coastal high courts in India have been given admiralty jurisdiction, which means that employability or more employment options have increased. Now in Gujarat High Court, before 2017, there was no admiralty jurisdiction, which Gujarat High Court was having. But now all the coastal high court have admiralty jurisdiction. So, and also all those shipping companies also have legal department. Shipping companies have legal department, and if the students will have some idea about maritime law, they have studied maritime law in their LLB. Of course, if some shipping company comes for a recruitment, it will surely hire a person who has background in maritime. So I think this is a very important area which can be brought to the students.
Yeah. Thank you very much. You have also answered a second question that is the career aspects of in maritime law. So definitely you discuss 4 5 very good points, so they can look out for those kind of opportunity in the market. Yeah. Another questions like for example. So what like another questions? I think there are some more questions are there. So related to assessment and then evaluations, what should be the strategy? What do you do from your side?
So I think related to assessment, first of all, I think the areas which are like gray, a lot of gray areas are there. I personally believe what I prefer is that while teaching the subject, uh, I allocate topic to my students. Because I don't want that they should like do some tell whatever is already written. There should be some area which has there's some gray area or research area which I can allocate them, and they can do the research. Another thing which I think is important is that we should take those issues which are related to our part of the world, which are concerned to the interest of India or South Asia, rather than making our student in an assignment to work on some problem which Europe is facing. Rather than selecting those topics, there are so many issues which our part of the world is facing. So we can motivate our student to take up those topics rather than, because already there are so many Europeans who are already there to work on European problems. Why we should invest our resources in working on their problems?
Definitely.
Literature is lacking in our part of the world. If you see Merchant Shipping Act, if you see Admiralty Act, if you search how many books are there in Merchant Shipping Act, there's no book available. It's very important for India. India is looking itself as a maritime nation. Government of India is investing in the ports. Now we need that kind of literature, and of course, like our students who are writing research paper as an assignment, those could be published. Like lot of scope is available. I think while allocating assignment, all those things should be done.
Yeah. And regarding what's your like experience with field visits, how what they see in field visit related to this course?
So when we talk about maritime law, teaching maritime law, like when we talk about Gujarat Maritime University, we offer LLM in maritime. So what we do is that we take our student to port visit, because port is a place where we can see the practical application of whatever we are learning in class. So port is one. Port field visit, of course, is very important. Field visit to port is very important. Uh, Also, in when it comes to internship, the shipping companies, the legal offices of shipping companies, their students can go. They can learn about maritime insurance or so many aspects, because maritime law is intertwined. So many areas are there: marine environment, marine insurance, ship arrest, shipping contract, maritime labor law. So many aspects are there, and of course, when it comes to field visit, port visit can be a must.
Definitely. Another question, what do you see as the most significant emerging trends or challenges in maritime law in the coming years, and how can legal frameworks adapt to address this issue proactively?
What are the emerging trends?
Emerging trend or challenges in maritime law in the coming years, and
Okay.
how can legal frameworks adapt to address these issues proactively?
Now, if you talk about challenges which maritime in maritime law, let me talk about Indian perspective. Now, we talk about ship arrest. I told, like there's Admiralty Act of 2017, where coastal high courts have been given this admiralty jurisdiction. They can arrest a ship. A problem which is there, that ship arrest procedure in India is a lengthy procedure. It's a very lengthy, it's a time-taking procedure. So they're having cases where like 1 year, more than 1 year has been passed in arresting. In once the vessel is arrested, in auctioning the vessel, 6 to 8 months have been lost. So one of the challenges is the delay, because like some of the countries are considered as arrest-friendly countries. For instance, suppose somebody has supplied bunker or fuel to a ship, and ship owner has not paid the dues. Then that bunker supplier, the person who has supplied the bunkers or fuel, that person can approach the high court wherever. Suppose the ship is in Singapore, so the person who has not been paid for supply of fuel can approach Singapore High Court for arresting that ship. Now Singapore is considered to be an arrest friendly country, because if you see the time frame within those issues can be resolved in Singapore is much better in comparison to India. Although in India, all the coastal high courts have admiralty jurisdiction, but that pendency is a big challenge. Now, again, when we talk about challenge in India, like if you see maritime neighbors of India, if you talk about disputes which India is having with its neighbor. Now, there are a lot of many disputes which happen with India and Sri Lanka. Many Indian fishermen are arrested by Sri Lankan authorities, and that happens in Indian side as well. That happens in between India and Bangladesh also. That happens between India and Pakistan also. Many Pakistani fishermen arrested in Indian jail, and many Indian fishermen are there in Pakistani jail. So, of course, this is again a challenge. We have to look out to this issue or any issue from the perspective of law of the sea convention. For instance, when we talk about arrest of a fisherman. Suppose some fisherman from Sri Lanka was found doing illegal fishing and India has arrested it. This can happen in Sri Lanka as well. Indian fisherman was found doing fishing in Sri Lanka and Sri Lanka has arrested it. Now, what Law of the Sea Convention talks about it? Now, Article 292 of Law of the Sea Convention talks about prompt release of vessel and the crew. Now, whether Article 2, Clause 292 of Law of the Sea Convention is complied when the countries are arresting the seafarer and detaining them and imprisonment, keeping them in imprisonment for years. There have been seafarers who have been in imprisonment for 10 years, more than 10 years. They are there in jail because they have done illegal fishing. Whether that can be reconciled with Article 292 of Law of the Sea Convention, which talks about prompt release of vessel and the crew if ship owner furnish the security. So, of course, there are challenges, but the need is to look to those challenges from the legal perspective, from the perspective of Law of the Sea Convention, from the perspective of the Indian laws which are implementing Law of the Sea Convention.
Yeah, thank you very much. We'll take up last question. Do we include SUA against safety of maritime navigation also under the subject? I don't know what is SUA, so
Yeah.
over to you.
So you're talking about suppression of unlawful activity. Of course, this comes within the maritime security law, because Law of the Sea Convention also talks about maritime security. If you see Article 100 of the convention, it talks about this aspect like all the states should cooperate for combating piracy. Article 105 of the convention says that any country, if he finds any pirate vessel or anybody who's engaged in piracy, the country has the obligation to arrest that person, to detain that vessel. So maritime security law, of course, which is one thing which is included within the Law of the Sea ambit. Yeah, there is suppression of unlawful activity convention in place. For maritime security, we have a separate treaty which is called as suppression of unlawful activity at sea. India has passed a legislation for implementing suppression of unlawful activity convention. So in India, there's a legislation which is called as Suppression of Unlawful Activity at Sea Act of 2002. This is specific legislation in India. Again, at the same point, if you talk about literature which is there in this legislation, on this legislation, nil. So of course, this is again an area, how many people have been criminalized or penalized by invoking the provision of SUA Act, Suppression of Unlawful Activity Act. All those aspects are gray areas and open areas or research areas. We can motivate our students to work on those aspects.
Yeah, thank you very much, Dr. Mohit. I request now Gaurav Kumar to give a formal vote of thanks to Dr. Mohit. Over to you, Gaurav.
Thank you so much, sir, for your insightful, informative, and comprehensive session on teaching strategies for maritime law. Sir, you discussed the relevance of maps in teaching law of the sea and its related rules, like the measurement of baselines and maritime limits, which provides a better clarity and understanding to students. You also emphasized on the practical aspects on some of the very important concepts of the law of the sea, like international conventions, exclusive economic zones, relevance of data, and international news updates, evolution of the law of the sea, its negotiating history, website resources, related human rights issues, history websites, and maritime law treaties, research in the gray areas, recent developments, challenges, Indian perspective, etc., which serve as an important teaching strategy while dealing with this subject and makes it much more effective, meaningful, and interesting for the students. So once again, thank you so much, sir, to share your valuable knowledge and experience with all of us, which was really very meaningful and beneficial, as many teachers find it very difficult to teach this subject in classrooms. Thank you.
Thanks a lot. Thank you very much.
Thank you very much. Thank you.
Thank you.